This is the criminal process element 1 regarding the search and seizure of evidence, and as we know, this has to do with the Fourth Amendment to the U.S. Constitution about arrests and searches. What I'd like you to do right now is open up your folder and go to your copy of the U.S. Constitution. Find the Fourth Amendment and look at the Old English wording in it before you do anything else. If you want to use the commentary part to help you afterward to understand things, that's fine, but at first, go to the Old English part, and I'd like you to do a little annotating. I'd like you to underline what you think are the key words and the main points of the Fourth Amendment to the U.S. Constitution, and jot those down in your lesson. So, pause the video. Now, like the other amendments in the Bill of Rights, the Fourth Amendment is designed to protect citizens against the power of the new government that was set up by the Constitution. Remember that people were very fearful about the government having too much power because the king had so much power before. And one of the things that the king used to do is go after people for political reasons. Well, the Founding Fathers set up the Fourth through Eighth Amendments for that particular reason, political reasons, not criminal ones. That's changed a lot nowadays, as the Fourth Amendment mostly applies to criminal cases. But whether it's a political case or a criminal one, you are entitled to due process of law, and that means the burden of proof is not on you, but on those who are charging you with the crime. The burden of proof means that you are presumed innocent until proven guilty beyond a reasonable doubt. In other words, it's not guilty until proven innocent in this country. It is innocent until proven guilty. And the gathering of evidence is the first step in this due process, if you will. Now, if you take a look a little farther down the lesson, you're going to see two definitions here: probable cause and reasonable suspicion. Now, we're going to start here with probable cause because, by definition, probable cause is what gets you accused of a crime in the first place. What they're trying to establish, and this is the definition that I use for it, what they're trying to establish is that you probably committed a crime. Now, that's quite a bit different than reasonable suspicion. Reasonable suspicion is just a reason to suspect you. If four women wearing the same outfit shoplift at Kohl's in Traverse City, it's reasonable to suspect that one of them could be guilty of the crime, and so it's okay to question all four of those people. But the one who has the watch in her purse that was stolen from the store, well, now you may not know that's the exact watch, but you have a reason to believe she's the one who probably committed the crime, and therefore you have probable cause. Once the police have established probable cause against you, then they have to get permission to take whatever action they're going to take next, and that's usually in the form of a warrant. The definition of a warrant is pretty simple. It's official permission to take an action of some sort. And there are really two types of actions that the police can take at this point. The first one, as you can see here in front of you, is a search warrant. It's official permission to search something. And here you have an arrest warrant, which is official permission to go ahead and arrest somebody. But there is a huge misconception about warrants that we need to address right now. Despite what everybody thinks, there is no constitutional requirement for officers to have a warrant in order to search something. As a matter of fact, most of the searches in this country are conducted without warrants. So how can officers do this? Well, all they have to do at some point in the process is establish to a judge that they had probable cause. They had a reason to believe that you probably committed the crime. If they can establish that to a judge, then a warrant isn't necessary for the file. They just have to establish probable cause. And in some cases, they don't even have to do that. If you give them permission to search your bag, they come up to you and ask you if they can search your bag, and you give them consent to do that, they don't even need probable cause or a warrant for that. And they can search your bag as long as they want to until you say you don't give your consent anymore. Now, of course, if they're halfway through the bag, they're going to finish that search, but you can stop that consent search anytime you want to. There are other searches that don't require probable cause. The most notable is the safety exception. If they believe that something is happening that puts people in clear and present danger around them, to borrow a phrase from the First Amendment, then they can go ahead and search it without needing a warrant or probable cause for that matter, like this guy is doing in looking for a bomb. The safety exception can also apply to homes based on what a police officer observes or a phone call that they get from someone else saying that they should check it out. If they believe that someone inside is in peril in some way, shape, or form, they can enter the house. There's also no requirement for a warrant or even probable cause in airports. This is part of what's called an administrative search, and they're conducted here and also in government buildings across the country. If you go to the White House, you're going to get searched before you enter, and it's the same way in a lot of other government institutions. Like a military base. If you go to a military base, they are completely legally allowed, under the guidelines of administrative searches, to search you without a warrant or probable cause. And probably most distressing to students is the fact that schools fall under the guidelines of administrative searches as well. A school administrator can pretty much go wherever he or she wants to search something under these guidelines. They don't need a warrant, and they don't need probable cause. Matter of fact, they don't even really need reasonable suspicion. They can pretty much search where they want to search under the guidelines of administrative searches. But, and this is a key point and I want you to be aware of this, it's probably better for them to have at least a reasonable suspicion and have that in their back pocket to make sure that they're covered. And it's important to note that border searches can be conducted without probable cause or a warrant. They really don't even need reasonable suspicion unless you want to say that it's reasonable to suspect that any car going across could be carrying something. I guess that would basically be enough. One other point to note here as well is that if you get put on probation, your rights in terms of searches and seizures can be lifted as part of the terms of that probation. A lot of times officers can search you whenever they want to when you're on probation just because, I guess, you've already established reasonable suspicion by committing a crime in the first place. Arrest situations are also a time when officers don't need a warrant or probable cause. If they arrest you for something, they've probably established probable cause or flat out seen you do something in plain sight. That is the plain sight stipulation. If you come across someone who is shooting someone else, you're not going to point at them and say, hey, I think you probably did something. It's pretty well been established that they did, so you're legal to go ahead and search. And also, please remember that they can search anything within your immediate control or within reach. If you are carrying a bag and the police stop you and you drop the bag claiming they can't search the bag because it's not on your person, you are incorrect. They can search anything that's within your basic wingspan. Officials can also search public property without a warrant or probable cause. Now, remember, a principal can search just about anything they want to whenever they want to, essentially. The police can do that almost as well because that locker that you like to decorate and claim is yours, it's not. It belongs to the taxpayers that funded that school. It is therefore public property, as are the things inside of it. And yet, people think that you have to have a warrant to search something. Now, of course, if it's a stationary object like a house, it's really a pretty good idea. It's hard to justify to a judge that you have probable cause just by wandering into a house. It can be done, but it's a lot easier and it's a lot safer in gathering evidence and allowing that evidence to be used in court if you get a warrant first. The biggest thing also is to remember that that warrant needs to cover not just the house, but the property. If you're wandering through a kitchen looking for a murder weapon and you see 12 freshly buried graves in the backyard with crosses on them, the names of the victims, and a neon sign that says, "My collection of people that I killed," that evidence cannot be used if the warrant didn't say you could search the grounds as well. Mobile objects, though, are a little bit different. You're not going to pull somebody over and then look at them and say, wait right here while I go get a warrant. That person's going to take off, obviously. So the police, all they have to do, again, is establish probable cause to a judge later on. There have been hot air balloons, skateboards, bicycles, airplanes, and all sorts of vehicles, boats, everything like that. Helicopters, I think I mentioned that, I'm not sure. But they've all been searched at one time or another because they are mobile and can get away. The court has also upheld the legality of aerial searches, whether you're looking for immigrants that are illegally crossing the border, or, as has happened in our area, helicopters looking for vast orchards of marijuana. one that was actually right across the school at one point. Remind me to tell you that story in class. And as you can probably suspect, searches at roadside checkpoints have also been upheld by the courts. There's also a stipulation called hot pursuit. If you are fleeing from the police, then they have reason to believe that you've probably done something, and they can search you when they catch you. That is called the hot pursuit stipulation. And the court has also approved the stop and frisk method, where you stop somebody and frisk them, not even based on probable cause, but just reasonable suspicion. Stop and frisk has been a very controversial measure in the United States these days because people think it's racial profiling. You're just stopping people randomly based on their race and frisking them. The police say that that's not happening, while other groups say that it definitely is, and that's an ongoing debate that continues in this country. The thing to remember is that reasonable suspicion can apply to almost anything, and all a police officer needs to stop you and ask you questions is a reason to suspect you for something, and that applies to border checks and all these other things we've been talking about. All they need is a reason to suspect that you may be involved in something. And once they establish probable cause or a reason to believe you've probably done something, well, then they can go ahead and do searches. So where does it stop? Well, the courts have said that it's unreasonable to search a home using thermal imaging looking for abnormal heat that would be needed for growing marijuana. They're not allowed to do that. That's considered home invasion. And if they pull you over, it gets a little murky in terms of traffic stops as well. Officers may order a driver and passengers out of a car while issuing a traffic citation and search for weapons to protect themselves from danger, but they really can't search the vehicle for any other crimes. Now, of course, if a hand is hanging out of the trunk, well, now there's probable cause, and a judge is probably going to allow the rest of that search. But even with all of the things that officials can do in terms of searching for evidence, seizing it, and arresting you, the fact remains that you have rights according to the Constitution, and that you, as the witness, are protected and presumed innocent until proven guilty. So whether it's the police initially getting the evidence, or people on the scene coming by to get evidence later on, or people working with the evidence in a lab, the bottom line has to be that it's got to be gathered and processed and examined according to legal means where it's not tampered with in any way, or the process is not tampered with in any way. Because if it is, that evidence cannot be used in court no matter how obvious the evidence is. And that is called the exclusionary rule. It basically means that if evidence was not gathered or processed by proper means, if it became tainted along the way in any way, it cannot be used in the court case. The exclusionary rule was most prominently supported by the 1961 U.S. Supreme Court case Mapp v. Ohio. I don't know her first name, so we'll just call her Miss Mapp, as you can see pictured here. Police entered her house saying that she was harboring a felon, but they didn't find him there. They had probable cause to enter the house, but not necessarily to search in some of the areas that they did. They found obscene material and arrested her for that. She took the state of Ohio to court, and she won her case, as the U.S. Supreme Court said that it was illegal for them to obtain that material in the house, and therefore it was excluded as evidence. Now, critics of the exclusionary rule, including some Supreme Court justices, argue that its strict application may permit guilty persons to go free because of police carelessness or innocent errors. They say the guilty should not go free because of a technicality. Supporters of the exclusionary rule respond that the Constitution is not a technicality, and that because everyone is presumed innocent until proven guilty, defendants' rights protect the accused, not the guilty, and that if you take the exclusionary rule away, you are taking away the rights of the accused. That's basically it. We'll move on to the next one about the Fifth Amendment. Thanks for listening.